The present lecture series would be devoted to cybercrime landmark judgments. So, in that regard, exactly, we would like to discuss some important landmark judgments relating to the Information Technology Act of 2000 and subsequently in relation to the Indian Penal Code. And in particularly in that regard, we would like to discuss the most important landmark judgment delivered in the leading case, that is State of Tamil Nadu vs. Suhas, Katti. So, here in the introduction, we would like to discuss the very provisions of Section 67 of Information Technology Act 2000 and Section 65B of the Indian Evidence Act, or as it was called then. But now it was called as the Evidence Act, and in particularly relating to electronic evidence as pertaining to this particular landmark judgment. So, let us discuss about the very facts and the facts of this case relating to online posting of defamatory statements, then harassment of a woman, and creating bogus accounts, then damaging the reputation of the women. So the issues those who were involved in this landmark judgment was relating to Section 67 of the Information Technology Act 2000, then Section 469 and 509 of Indian Penal Code of 1860. Then we will discuss about the contentions or the arguments presented by the parties, then the judgment. Then we will make a critical assessment where we will make reference to some important landmark judgment in that regard. Sri Kumar versus State of Kerala judgment, then Janhit Manch versus Union of India. Then we will finally discuss about the conclusion. So, this landmark judgment relating to Information Technology Act and having been determined in 2004, the case attracts attention as it was one of the first cases having number of crucial elements taking its significance to in itself. The incident in connection to this case also encouraged more people to come forward and report cyber crimes committed. The case is significant because it marks the very first instance of online evidence submission in accordance with the provisions of Section 65B of the Indian Evidence Act, the Information Technology Act, and its implementation. In particularly in this case, had a notable impact and benefited both the courts and the general public, since it sets a standard for the courts and encouraged and strengthened the people in report regarding cyber harassments and online orientation. So now we'll go to the very facts of the case as we have expressed that. Here the petitioner was the state of Tamil Nadu and the very respondent was Suhas Katti. And the bench that was deciding this important landmark case was Court of the Chief Metropolitan Magistrate, IGMO. And the very judgment was delivered on 5th November 2004. So the very fact of this case, what it contains, that the case upon referred to as Suhas Katti case involves the posting of insulting and defamatory statements online concerning a lady who was divorced, and a court of chief metropolitan magistrate in Ignore in Tamil Nadu. The accused claimed to be a friend of the victim's family. Further, the accused was quite disappointed since he wanted to marry the victim, Miss Rosalind, but she ended up being married to someone else. He made another attempt to marry her after her divorce, but as she refused, he turned, and due to the inability to accept the rejection by posting her phone number and offensive remarks on numerous forums in an effort to upset her and give the impression that she was soliciting. Consequently, the victim began to get a lot of annoying and degrading calls from people who thought the woman was soliciting, which was the end result. So the victim created, so the accused created a bogus account in the name of the victim is Rosalind with the objective to damage the victim's reputation in order to transmit such offensive statements on Yahoo.com. The victim filed a complaint in 2004 as per the provisions under Section 67 of the Information Technology Act 2000 and under Sections 469 and 509 of the Indian Penal Code of 1860 based on the aforementioned facts. After receiving the report, the police detained the suspect and the accused, who was the Mumbai best friend of the victim. So the charges that were framed against the accused were under Section 469 of Indian Penal Code, which states forgery for purpose of harming reputation of another person. Then under Section 509 of Indian Penal Code of 1860, which provided any kind of word, gesture, act intended to insult the modesty of a woman. Further, the information report as it was consisting violation of Section 67 of Information Technology Act 2000, which states providing publication or submission on electronic mode that is against the will and is to cause defamation and harm into the reputation of another person. So the issues involved in this case, that is State of Tamil Nadu versus was Katti in 2004, as the accused created a bogus account in name of the victim, Miss Rosalind, with the objective to damage the reputation of the victim in order to transmit such offensive statement on yahoo.com groups. Further, the victim filed a complaint in 2004 February under Section 67 of the Information Technology Act 2000, including the provisions of Section 469 and 509 of the Indian Penal Code of 1860. Based on the aforementioned facts, after receiving the report, the police detained the accused, the suspect, who was a Mumbai-based friend of the victim, and the very charges that were framed against him, the accused, were in connection to Section 469 of Indian Penal Code, which in particularly provides regarding forgery for the very purpose of harming reputation of another, and Section 509 of Indian Penal Code of 1860, which exactly provides that any kind of word, gesture, or act intended to insult the modesty of a woman. Then also the charge contained Section 67 of the Information Technology Act 2000, which provided regarding publication or submission of any offensive matters on electronic media or mode that is against the will and is to consider too as defamation. So, the very contentions and the arguments presented by both the parties, as per according to Section 469 and 509 of the Indian Penal Code of 1860 and Section 67 of the Information Technology Act 2000, the accused was found guilty in this instance landmark as State of Tamil Nadu vs.Suhas. Katti. The accused as was found guilty as because as it was found the divorced woman, the victim, Miss Rosalind, who was a victim and was the accused were friends and classmates. The accused was a Mumbai resident. Everything began when the victim checked her read email and saw two pornographic messages sent by the accused on the particular dates that here we could cite as February 7 and February 9, 2004, in which all the victims' information was provided and which the accused afterwards distributed to 5 sex groups via the Yahoo website or yahoo.com. Upon seeing this, several people made calls and text messages in an attempt to reach the victim, Miss Rosalind. She is seen as a sex worker by the individuals in that particular year. It was in the year 2001. So, the woman tried to make a marriage and finally she married to Jai Chand Prajapati of Uttar Pradesh. And ultimately, as due to the failure of the marriage and due to a divorce, as it was resulted by a court order in 2003. So during her time in college, she learned that one of his classmates had once done the same thing. He also said that he wanted to wed the victim as it was made by the allegations in the FIR by Miss Rosalind, the victim. Even after the divorce, the accused lingered at the victim's home for 10 days while claiming that he had to travel to Bangalore for an interview. As he makes her a second marriage proposal, however, the victim, Miss Rosalind, eventually became annoyed and did not find it nice that he kept phoning and sending messages, so she banned the accuser from anywhere and everywhere. Because of such anger, the accused committed this crime. And as the accused further claimed that Jai Chand Prajapati, the victim is Rosalind's divorced spouse, is responsible for all this that happening. The court, however, rejected the premises that everyone else accused of the act must have committed it on their own. He added that this was only a simple reaction to a victim's rejection of him. So finally, the judgment was delivered on 5th November 2004 by the Additional Chief Metropolitan Magistrate of Madras issued the order and the ruling, where it was read as the very judgment and ruling by the Additional Chief Metropolitan Magistrate. The accused is found guilty for the offence committed by him and for which he must be found guilty and sentenced to undergo rigorous imprisonment for 2 years and a fine of Rs. 500 under Section 469 of Indian Penal Code and for the offence under Section 509 of the Indian Penal Code. The accused is sentenced for 1 year and in pursuant to the provisions of Section 67 of the Information Technology Act of 2000, the offender faced a harsh 2 year jail sentence and a fine of Rs 4,000. The accused must pay the fees and serve their time in central jail in Chennai, as it was the ruling of the Additional Chief Metropolitan Magistrate of Madras and Chennai. So now you would like to make a critical assessment and to conclude the very lecture on this very important landmark judgment state of Tamil Nadu vs.Suhas, Katti, which was decided in the year 2005. The very principle that a decision should be based on an accurate examination of the evidence and the facts of a particular case is well established, and in the present case it should be noted that the Honorable Judge made the correct decision regarding the case that was filed under Section 67 of the Information Technology Act of 2000 and 509 and 469 of the Indian Penal Code of 1860. The culprit was given a reasonable punishment since his actions were immoral and against the prevailing legal provisions and law. Posting pornographic content and disparaging women are both dishonorable and it would constitute derogatory, defamatory, and also violating the very modesty of an woman. So it should be highlighted that the women confront innumerable sexual insults and criticisms in Indian society, and under those circumstances, the accused uploaded such offense content online, tormenting the petitioner and damaging her reputation. The petitioner experienced unfavorable circumstances while residing in society, and those experiences cannot be taken away from her. So the court correctly construed the word of sense in this instance case, since the Kerala case which lacks standards for what constitute an offense conduct. So in that connection we would like to discuss the Kerala case Sri Kumar versus State of Kerala. So the Kerala High Court ruled that even when a statement is harsh, it is not offense unless it makes the hearer feel sexually aroused. This significantly reduces the definition of the word offense and limits the ability of the court to administer justice. But at present, the current lawsuit prompted the government to partially enact Section 67 of the Information Technology Act 2000, which is still a prevailing contentious issue And in this landmark judgment, we would like to discuss another important judgment, and that is relating to Janhit Mansuhas Union of India, where the petitioner requested that the respondent issue guidelines for the prosecution of offenders who publish sexually explicit information that negatively affects the nation's young in accordance with Section 67 of the Information Technology Act 2000. To arrive at its decision, the court in this instance thoroughly questioned the expert witnesses. So in 2004, the Information Technology Act regulations were not as strict as they are now at present, but the Honorable Court has correctly punished the offender by applying the regulations in a very specific manner. The court has offered an alternative course of action for handling comparable case proceedings in the near future in order to uphold justice and punish the perpetrator. The court also enforced Section 67 of the Information Technology Act of 2000 effectively. So, at the present case, in the cyber world, it was wearing very importance, as there were many things to keep in mind while one to read it. This alone gives the value regarding this particular case, the case of State of Tamil Nadu vs.Suhas. Katti, as we are discussing, was the first to be filed under Section 67 of the Information Technology Act of 2000, bringing to light the ramification of publishing pornographic content and saying that any offender, even cyber criminals, cannot be exempted from their responsibility. And this case was resolved in just 7 months because to the remarkable efficiency of the Chennai cyber cell, which is significant in and of itself given the urgent need for a rapid resolution of that issue of 2004. So the case encouraged several women to come out and discuss the same issue they were facing since prior to this case. It was embarrassing for the women to discuss the harassment they were experiencing in public. People have been made aware that their legal rights may also be protected online and that they should have trust in the very legal system. So the court's introduction of the validation of a person's as a expert and the admission of electronic evidence as provided under Section 65B of the Evidence Act are most significant development. So, the present case that we are discussing regarding State of Tamil Nadu vs.Suhas, Katti, has a lot of relevance even now, as forgery of electronic evidence was also recognized as a felony So, this case illuminates several as yet unexplored avenues that the legal system might follow to provide justice in the realm of cyber crimes, and as such, it is significant. So now we would like to conclude our very lecture relating to this landmark judgment state of Tamil Nadu vs. Katti as it was decided in the year 2005 in the context of cybercrime. Every aspect of a person's existence in the 21st century evolves on cyberspace, which gives rise to both the benefits that the internet offers and the crimes that take place. It appears that controlling these online crimes has now become a top priority for the governments. The regulations governing the internet were not only strict because little harm had been recorded or inflicted until recently in the Indian environment and what the internet had only began to exist. However, the Information Technology Act of 2000 and its application as it was applied in this present case had a historic influence and aided the public as well as the courts by setting a standard for the courts and ensuring and empowering individuals to file claims against wrongs like harassment and defamation, among other wrongs, on the internet. So, in connection to India, this was the first case relating to the very provisions of Section 67 of the Information Technology Act 2000 relating to this very landmark judgment. State of Tamil Nadu vs. Katti, where the accused was convicted for the offences committed as per the provisions of Section 67 of the Information Technology Act 2000 and also those offences committed under sections 469 and 509 of the Indian Penal Code of 1860. So hereby we complete the lecture on our first most important case in this series relating to landmark judgments in connection to cyber laws or cyber crime. So we have hereby discussed in detail about our first most important delivery of lecture on the first most important landmark leading to conviction of the accused, and that is state of Tamil Nadu vs. Katti in the year 2004.